But if we look at the Canadian example, in 2022, which I think is the last year for which we have figures in Canada, 4% of all deaths in Canada were assisted dying. That is a hell of a lot more than the 1-2% that you're talking about.
It is, but it happens in a jurisdiction under legislation that is very different from what I'm proposing, what is in place, as I say, in Australia and the US. But Alex, I think let's kind of recap on why Canada is where Canada is. The legislation there was not brought forward either as a member's bill or a government bill. It was brought forward in response to a legal challenge in the Supreme Court in Canada that the ban on assisted dying was unconstitutional under the Canadian Constitution. The court found in favour of that. Parliament, in a sense, was kind of rather dragged kicking and screaming to introduce legislation at pace. And I think even supporters of the change in the law in Canada, on reflection, would argue that the pace at which they sought to introduce it hadn't been helpful. But even then, the legislation that was passed was not deemed to have given full effect to the court ruling. An appeal was lodged, the appeal was upheld, and the Canadian Parliament had to then further amend the legislation. But it has always been more expansive. I mean, in a sense, as I say, no two models are exactly the same, but it's more akin to the models that we've seen in Benelux for a good many years. And in a sense, when you allow access on the basis of suffering rather than terminal illness, I think the potential for that to be accessed by a much wider range of individuals is not hard to see. So as I say, I think the numbers that we see in places like Australia and the US are more likely to be a reflection of what we would expect to see here in Scotland.
But there has been a sort of, if you like, a death creep, if you like, to put it bluntly, in Canada, where the eligibility has been expanded. We also see that in the Netherlands, where, for instance, people suffering from depression have been ruled to be eligible for assisted dying because the quality of their life has been, so diminished, et cetera, et cetera, et cetera. And so, are you not concerned that there is, at least as a theoretical matter, the possibility for that kind of expansion of eligibility?
No, because I don't think we need to dabble in the realms of the theoretical. I mean, I think, as I say, that there is...
Well, but it has expanded in other jurisdictions.
It's expanded in jurisdictions where the criteria have always been more expansive. They've always been more permissive models. As the Health Committee in the House of Commons established in a report published back in February this year, after an inquiry lasting 18 months into assisted dying and end-of-life choices, there are no examples of a terminal illness mental capacity model of assisted dying that has expanded in its criteria. So, I mean, Oregon was the first jurisdiction to introduce legislation of this type back in 96, 97. And there has been no expansion of the eligibility criteria there at all. Now, medical diagnoses with the advances of medicine and all the rest of it may evolve over time. Individual medics may view the same patient and come to slightly different decisions or conclusions about that patient. But there is no expansion of the eligibility criteria at all in any of the jurisdictions where a terminal illness mental capacity model has been introduced. So I get the theory and that opponents want to discuss Canada, Netherlands, Belgium. I understand why they want to do that, because they don't want to see a change in the law at all. I mean, it's worth bearing in mind that in all those jurisdictions, the laws themselves command enduring strong public support and indeed the confidence of the medical professionals that wish to engage in it, as well as more broadly the medical profession, albeit that the conscientious objections apply in those jurisdictions as well. But it's a different case to say, because this has happened in Canada, this could happen here in Scotland, because there is no international evidence of, as I say, a terminal illness mental capacity model morphing into something more expansive, nor indeed any more permissive model that's retrenched into a terminal illness mental capacity model. And
But you have surveys. Sorry about it. You have surveys in Canada of people who've been through the procedure and so on, or are talking about it and so on, and robust surveys and so on that suggest that as many as a third of the people who go through assisted dying in Canada, and I assume that this would be broadly consistent with other jurisdictions too, say that one of the reasons they are going forward with this is that they do not want to be a burden on friends, family in particular, and so on. So there is, that isn't coercion per se, but it is, if you like, a sort of self-imposed coercion. Is that not a concern for you?
It's a concern that people feel they are a burden. I think those same surveys, and I know that the figure was used for Oregon as well, but in those same surveys of patient sentiment, the overriding and overwhelmingly consistent reason for applying for this was the loss of agency, the loss of the things that made life for them worth living, the inability to do the things they've been able to do. The sense of burden was cited as a factor, but much lower down than these other sort of criteria, these other reasons. Now, I think the fact that you've got a process in place where medics are discussing with the patient who has made the application for an assisted death the rationale for why they got to where they got to. I struggle to think that if a medic had concerns around why it is that the patient before them was seeking to access an assisted death, that they would sanction it rather than looking at ways of trying to ameliorate their position. So in a sense, it's more safeguarded than what we have at the moment, because we know that sense of burden exists. And we also know that the level of suicide amongst those with a terminal illness is twice what it is for the population as a whole. We know that people are taking matters into their own hand, often alone, behind closed doors, without consulting family, without being able to consult medics because of the legal implications. And for those who have the financial wherewithal and the physical capacity to get to Switzerland and access to services at Dignitas, we know they're doing that too. So I think that the notion that this isn't happening already, the consequences of the ban on assisted dying are leading to vulnerable people being left very isolated and without any ability to talk openly about how they're feeling, what it is that they feel is, I think, is intolerable. I mean, even if it's getting people to a place where they engage more with palliative care. I mean, I know that we'll come on to this. There's a kind of feeling that introducing assisted dying will draw away from palliative care. Again, the international evidence absolutely contradicts that. That in a sense, the conversations that you're having around an application of assisted death involve a discussion around the range of options. And the committee heard a couple of weeks ago from two witnesses from Australia who confirmed that the engagement level with palliative care in all of the states in Australia had gone up. So in a sense, ignoring this, trying to kind of push it into the shadows and behind closed doors, it just seems to me a wholly unacceptable place for us to be, and that those that feel a burden need the support, and it's not being provided at the moment.